Good evening, this is John Milburn. This is Laws 11046, and tonight for Law and the Environment we're dealing with environmental issues and the common law. The problem for this week is problem 3.0, and at the tail end of this discussion I'll make some comments about your responses to problem 2.0 from last week. So we have a number of people joining us live. Thanks for doing so. As always, please feel free to unmute your microphone and make a comment, ask a question, or use the chat facility. For those of you that are viewing this at a later time, hi, I hope you can join us at some stage. Now next week, which is the 31st of March, the session will be much later. That'll be at 7:30 p.m. I apologise, it's a late start, but it may mean that we've got some people that can't otherwise join us because of other time constraints. So we might have a few new faces along next week. And next week will actually be a joint session with another class that I run. So in the material that you have been given for this week, you would have noticed a Zoom session with Judge Morzone. Now, it was about ethics and etiquette and procedures, so none of that is directly examinable in this course, but I think it's useful for you to consider that because it may have some bearing on the way you think about the cases that you read and provide some useful background. Now, of course, I completed that session with His Honour prior to his appointment to the District Court. So please don't address His Honour by his first name, as is the case in the recording. If you come across His Honour in private conversations outside of court, then the customary title is Judge. But in court it would be, of course, Your Honour. Now, if you have any questions, please let me know. One thing I will say is that now that you're studying environmental law, you may be besieged with questions from people. It's very common. It's a very topical area. I went through the Courier Mail yesterday and there were discussions about Clive Palmer's nickel refinery and the cost of cleanup. There was various other discussions about planning and environment law in the context of the University of Queensland, sending information to a number of people in the alumni, including judges of the District Court and Supreme Court, and His Honour Judge Rackham not being too happy about it. So I guess I just use that as an example of what I happened to pick up today, yesterday's paper as it was, and saw there's always something about environmental law and planning and environment law. Now, people may regard you as experts in the area now that you're studying it, and they might even say things like, well, as you know, etc., etc. Just be comforted by the fact that lawyers practicing in the field always have to go and check the legislation, always have to check the case law. So just because you may not happen to know something off the top of your head, that should not mean you don't feel as though you're failing yourself in that regard. And it's always safe to look at the legislation and look at the case law. So as we discussed early on, there's really the primary sources of law, which is the legislation and case law, secondary sources of law, things like Bates' textbook. Always try to go to the primary sources if you can and make sure you look it up. And don't be ashamed to say, look, I don't know what that is, but I will look it up. And part of my role is to ensure that you've got a good ability to know where to look so that you've got the reliable information. And if you feel during the course that you don't know where to look to find out answers, then I'm not doing my job properly. And please give me a little kick up the backside and tell me that you need to have better information so as to access the law correctly. I haven't given you all the material yet in terms of what to access and where, but we'll progressively provide that during the course of this semester or this term. Now, when we talk about the common law, we're really talking about judge-made law. We're talking about the law that is made through the court system. And prior to the introduction of legislation in the environmental law sphere, there really was only common law. And legislation is really now overtaking the common law as the main part of our primary source of law, if I can use that term. And of course, as you'll all remember, legislation trumps, if you like, if I can use that term, case law. So it is going to be the case that if legislation conflicts with case law, then go with legislation. Now, when we talk about the common law, we're talking about something which is created as a result of the litigation process. A judge has made a decision. And of course, this all occurs at the third level of government. And I will talk about that separation of powers. Some of the answers were really very good in Moodle, so thank you very much for contributing. I've now added some further comments. Don't for a minute assume that just because this is my take on the question, that means that is the right answer. What people have written is excellent and in many ways much better than what I've written. But the importance of that is that some of these things might be exam questions. So by adding your responses, listening and looking at what others have provided, you'll have a much better and easier task when it comes to the exam. Anyway, back on topic. So we've talked about the separation of powers. It's all pretty basic, I guess. Parliament, executive and the judiciary. Case law, common law, comes as a result of what the third level of government, that is the courts, have to say. But when it comes to dealing with environmental law where people are dissatisfied, bear in mind that members of the public may have an opportunity to express their concerns about environmental law at three levels. Now, they may be unhappy with legislation, such as, I don't know, the Sustainable Planning Act, or which has, general effect, or specific legislation such as the Century Code Development Act. Now, that's at the parliamentary level, and the remedy there for someone who's not happy about that environmental law is to lobby, to seek change at the time of the election. But of course, it's not possible for an individual or a company to change what Parliament introduces by legislation. That's got to be done by legislation. Now, the second way is that at an executive level, planning schemes can be considered and implemented. And the executive has power to introduce planning schemes which have an environmental impact because that power is conferred upon them by the Parliament through delegated legislation. So planning schemes are introduced by the executive based on the delegated power to do so, and individuals can of course lobby the introduction of planning schemes, but they again have no right of appeal against the executive approval of a planning scheme. So it's very important that if you want to have your say, you do so at an early stage before the planning scheme is introduced. Now, of course, there may be ramifications for councils at the time of election. They may be unhappy with the way in which executive decisions are being made by assessment managers. Assessment managers are typically representatives of the council. So there is all of that. And it may be that some of the decisions that are made by assessment managers at an executive level relate to certain types of applications that leave it open for people to go to court and to make a complaint in that regard. And that will then bring us into the third level. Just as an aside, and I'll touch on this a bit more, but when we talk about decisions by an assessment manager and the right of a party to go to court to challenge that, and I'm really talking here about the interplay between the second level of government and the third, leading from one end to the other, if that makes sense. Bear in mind that the executive the assessment manager, which is the executive, can make decisions in relation to certain applications, and sometimes members of the public, objectors or submitters as we call them, can challenge the decision, but only if it's an impact assessable development application. Gosh, that's a lot to take in, isn't it? So I'll just go through that again. When an assessment manager makes a determination at the second level of government, which is executive, the party which is directly affected can challenge that decision by going to, say, the Planning and Environment Court. But outsiders, people that want to challenge the environmental impact of the decision of the assessment manager, can only go to the Planning and Environment Court where the decision relates to an impact assessable development application. You can let that go over your head a little bit. it'll become more clear when we start talking about the planning aspects and IDAS, which is, I think, in about week 5 or 6. Anyway, development applications can become the subject of litigation, and that is where the assessment manager, which is usually the council, approves the certain development which is subject to opposition. That's if it's impact assessable development, or approves the development which contains conditions that are subject to opposition, or the council refuses a development and the developer seeks to appeal, or others say that it's subject to certain mistakes, and in those instances the matter goes to the Planning and Environment Court as a merits appeal. Now, I'm doing a lot of talking. I'm not sure if I'm making a lot of sense. I hope that I am. I'm moving fairly quickly, but if you have any questions, please ask. Use the chat facility or unmute your microphone. But I'll continue. So, what we're talking about here is the second level of government. The executive makes a decision, somebody's not happy, and therefore that person goes to court. But the rider is that if you're a concerned citizen, you can't necessarily go to court over everything. There are certain rules about how you get to court. We'll talk more about those in the context of what we call standing, which is your ability to stand before a court and say, essentially, I object. But before we even talk about that, you've got to bear in mind that it's only impact assessable development applications where a submitter or an objector can go to the Planning and Environment Court. Have a look in the Sustainable Planning Act. Schedule 3 defines the term impact, and IDAS provisions in the Sustainable Planning Act, that's the Integrated Development Assessment System, that provides kind of the mechanism, and we'll talk about that in more depth later. Okay, so we're talking about the common law. The common law is the court-made law. Before we can talk about the court-made law, we have to have a basic understanding of the sorts of cases that end up in the environmental sphere in the courts. And in the Queensland context, overwhelmingly, that will be either the Land Court, which is really to do with mining matters, or the Planning and Environment Court, which is really to do with development applications. So let's just talk about the sorts of matters that are dealt with in the Planning and Environment Court. Now, bear in mind that the P&E Court deals with issues to do with merits appeals. Really important concept, this. We'll talk about it throughout the course. Merits appeals are usually those things determined in the Planning and Environment Court. Not always. There might be other matters that are dealt with in the P&E Court, but generally speaking, if you're reading a case about a particular development, then it's probably going to be a merits appeal. Now, a merits appeal is where the Planning and Environment Court receives the application for reconsideration, but in a way where it essentially starts from scratch. And the term we use, the quaint little term we use, is the Planning and Environment Court in a merits appeal sits in the shoes of the assessment manager, so to speak. What that means is that the court is charged with the responsibility of making the correct and preferable decision in relation to the matter, and it must determine the application on its merits, hence a merits appeal. So the court in a merits appeal is not focusing on the decision-making process of the assessment manager, and in many ways essentially ignores what the assessment manager decided. That's kind of irrelevant because the court is determining the matter as if it was the assessment manager and saying, and it's a little bit pompous, but essentially the law says the Planning and Environment Court is making the correct and preferable decision. It might be the same decision, but it might be a different decision. And in that context, the Planning and Environment Court considers the relevant legislation and the case law in coming to its decision. So when that court makes a decision in a merits review, the decision can become part of the common law, but you've got to bear in mind that it is a decision that relates to a particular development. So its ability to bind future courts, a particular decision, the ability to bind future courts is somewhat constrained by the fact that this is really a decision about a particular development, and it may or may not have such wide-ranging ramifications into the future. So common law is a little bit restricted when it comes to decisions about merits reviews because of the specialised nature of what the court was asked to do. Gosh, I hope that makes some sense. All right, now, when you're considering court decisions in relation to review matters, we'll talk about this later, but I just want to flag the fact that there is a difference between what we call merits reviews, which are the matters that I've been talking about, where the specialist court or tribunal considers the application as the final arbiter of the merits of the application. And I do that in QCAT for different things. The contrast to that, and I'm just going to go to gallery view to see who's around. Hi, everyone. The contrast to that is judicial review, and judicial review is where a party challenges a decision based on its legal validity, not the facts, and the court or the tribunal does not have power in judicial review to enter into an investigation of the original decision or make a decision in substitution for that of the original decision maker. So a merits review is where the court steps into the shoes and makes the decision as if it's the assessment manager. Judicial review is where the court looks at the way in which the decision maker went about the process and makes a determination as to whether the decision maker applied the law but does not make the decision for the decision maker. Okay, so there are a lot of differences between merits reviews and judicial reviews, and you contrast all of that to other things that courts do in the Planning and Environment Court, such as civil enforcement, which is maybe granting an injunction or making a declaration, or otherwise enforcing various orders that need to be enforced. So that when we're talking about case law, just think about the type of decision that the court is making. And as mentioned, most of the decisions that relate to a development application, that will be a merits review. Okay, any questions arising from that?
Just one. I'll pick up one question with the judicial review. So you said the judicial review is challenging the validity of the law. Is that challenge from the decision that was made in the tribunal or the original decision maker?
Generally, it's originally the original decision maker. So judicial review is a review by the judiciary of a decision made at an executive level, but does not constitute a decision about the merits of the case, but more the legalities undertaken by the executive in going about its decision-making process. I hope that makes sense. Now, and we will talk more about this later, but in the context of, say, judicial review, one thing is if a party presents a case and the decision-maker says, I disagree, and gives no reasons, or doesn't even listen, so I'm not listening, or is clearly biased by saying, well, you know, you people, you're always doing this sort of thing, making generalised comments and clearly showing bias. Well, in judicial review, those sorts of practices are considered by a court, and the judiciary makes a determination as to whether the decision maker in that context actually applied the law properly. Does that make some sense, Tim?
Yep. And if that decision is then, if they consider it that there has been bias or that they haven't applied the law correctly, does that then nullify that decision and then they can go through that process again?
It can do. There are a number of powers available to the court in judicial review, and one of those is to send it back to the original decision maker or send it to a different decision maker, or to declare the decision null and void, etc., or it can affirm the decision. So a number of options. And I think in the notes that's covered in, I don't know, it's down the track anyway. It's like week 10 or 11. So if you want to do some advanced reading, there's some commentary there.
Okay.
But great questions. Thank you very much. Any other questions? All right, I'll just go back to speaker view. All right, so the point of that exercise is just to say, look, mostly it's going to be merits reviews that you're reading about. And just look out for that. Just ask yourself, is this a merits review or what is it that the court is actually doing? And merits reviews are available in Queensland to do with decisions that relate to the Sustainable Planning Act, primarily in the Planning and Environment Court. Merits reviews are also available in relation to administrative decisions in the federal sphere, but that's much more limited. So you won't see very much of that at all. Just as an aside, I've mentioned I'm a member of QCAT, which is the Queensland Civil and Administrative Tribunal. In Victoria, the merits review work undertaken by the Planning and Environment Court in Queensland is actually undertaken by, if you like, our sister organisation in Victoria, VCAT. So you might see some decisions that relate to planning and environment decisions and applications in the Planning and Environment Court in Queensland, or you might see it in VCAT if it's a Victorian decision. Okay, now in terms of the other material in week 3 notes, I think we've also got Zoom video that I did with Rod Litzter QC in relation to Predajon case. It's a detailed commentary about a merits review to do with a particular development application. And you might find that is of some use when it comes to trying to describe what happened in Exchequer property finance against Fraser Coast Regional Council for your assessment piece. So it doesn't directly relate to it, but it might provide some useful hints. Now, part of understanding the common law is also understanding delegated legislation. I think we've talked about that. I think people have got their handle on this. But it's essentially a way that Parliament provides local government with power to make rules, bylaws, regulations in relation to a wide range of things. And they do that primarily because it means that not everything has to be dealt with at a parliamentary level, and it can cater for change, and it's much quicker and easier, etc. But bear in mind that when you see all these bylaws and rules and regulations and planning schemes, etc., you know, much of that which is created at the executive level is conferred upon the executive by parliamentary law. Otherwise, the executive has no power itself constitutionally. Anyway, let's get back on topic. We're talking about common law, and at common law, the rule is that a landowner is able to exploit all resources on the property. And the courts have always upheld that view. They've always tried to protect the rights of a landowner. And but there are restrictions, and I think we talked about this last week, that if you look at a deed of grant of land, there are certain restrictions, and one of the important ones is in relation to Mineral Resources Act, where there are mining rights which are retained by the Crown. We talked about the Crown last week, so bear that in mind. Now, here's the really difficult part. When it comes to environmental law, everyone wants to protect the environment. And I'm not being critical, I'm just saying that's what we want to do. It's very important. We want to protect the environment. But in protecting the environment, sometimes we need to create laws that have a direct effect on landowners. And last week we talked about some comments in relation to Spencer's case, where His Honour said, look, this is all very well, but what the government is doing is really asking Mr. Spencer to suffer a personal loss for the greater good, and really just flagging that as this is the whole dilemma. This is the whole issue of compromise between what's good for everyone and the rights of the individual landowner. Because at common law, landowner can do whatever they like, subject to some very specific tortious notions and obligations. So we'll talk about that in a minute. But now we talked about last week the ability to use property in a certain way, and the fact that sometimes restrictions are compensable, but other times they are not. And that goes into that whole compensation area that we discussed, so bear that in mind. All right, so in terms of common law, the main areas that survive are to do with, say, nuisance and negligence. Now, negligence is a common law claim that is available to a party that suffers a loss in circumstances where someone else owes them a duty of care, and the other person might reasonably have foreseen that their actions would have an effect on the other party if they carried out an activity, or they failed to carry out an activity and they did so negligently. So in more simple terms, if you do something and it affects somebody else, then you will be liable to that other person for what you did if you did so negligently. And negligence is all about whether it was reasonably foreseeable that what you did will have an effect on somebody else. So, I don't know, if I was to put a snail into a bottle of ginger beer, and the person who bought that ginger beer got really sick, then you might say that by putting the snail into that bottle of ginger beer, I was negligent, and it was reasonably foreseeable that I didn't know it would be Mary Jones, who lives in Tasmania, who was affected by that, but it's reasonably foreseeable that whoever gets that bottle is going to be sick. So therefore, I, as the manufacturer, are responsible under negligence. Does that make sense? So that's what negligence is all about, and it still applies. So in environmental law, even though we're talking primarily about legislation, and we're talking about, which is the first level of government, and we're talking about the decisions of the decision maker at the executive level, bear in mind that common law rights such as negligence still do apply and can apply in certain circumstances. The other big one is nuisance. Now, nuisance is more than just, in the lay sense, someone's being a nuisance. It has a more technical meaning in torts law. And nuisance is designed to protect the rights of a landowner against interference with their rights. So, for example, when environmental hazards such as noise or fumes intrude onto somebody else's enjoyment of the land, then that person affected may have an action in nuisance against the other party that caused the environmental hazard. So that would be a common law action in nuisance. Now, have a look at Ball against Consolidated Rutile. It's a 1991 Queensland decision. It's 1991 Queensland Reports 524. In that case, the defendant was a mining company. It was conducting sand mining operations on North Stradbroke Island, Australia, and it formed a sand dune, and that sand dune slipped and caused significant erosion of the land. And you can understand that by doing that, the sand and the soil and the vegetation spilled into Moreton Bay. And at that stage, the plaintiffs, commercial fishermen, sued the company on the basis that what they did in creating that landfall, that slide, that pollution, actually caused a nuisance to them because their nets, etc., couldn't work properly. The court ultimately held that because they could no longer use the nets, that did not constitute an actionable interference, so the case was lost. But it's a good way of showing how environmental actions can still be the subject of common law actions in the context of what we're discussing. But it's really, the reason this week's not that important is that common law actions are not the main, they're not the main player. when it comes to environmental law. So that's why we're just dealing with it this week. One thing I'm nearly finished now, and you've been very patient. We're getting much closer to the time that I aim to do with these things. But the defence of statutory authority is really important. We'll talk more about this in the context of, criminal law type activity, but have a look at section 319 of the Environmental Protection Act 1994, and it says that a person must not carry out any activity that causes or is likely to cause environmental harm unless the person takes all reasonable and practicable measures to prevent or minimise the harm, and we call that the general environmental duty. Now, the reason I mention that statutory provision now is to ensure that you don't put the blinkers on when it comes to considering an answer to a particular legal problem. Because, coming back to that case of Ball against Consolidated Rutile, if you are a torts lawyer, if you're a compensation lawyer, it's very easy to say, this is a nuisance case and I'm only going to pursue this as a nuisance case. But if you're an environmental criminal lawyer, you might think, oh, this is to do with the Environmental Protection Act. This is, quasi-criminal offence. And maybe I can argue that the company failed in its general environmental duty and take action under the Environmental Protection Act. So you've got to remember to consider the statutory provisions, and you've got to consider the different branches of law like torts or criminal law in the context of any one discussion. If there's any questions about that, please let me know. All right, now just finally, I'm going to share the screen now, if I can succeed in doing that, and go to, you'd think that I would have had this on the page already, but I changed the page when I was getting there. So I'll just share the screen now. You should see the Moodle page. I'll just pan down to question number 1, which was at the end of week 2, problem 2.0, and some really good answers there. Thank you everyone who did contribute some responses, and I've put in my 2 cents worth. But bear in mind, this is not the be-all and end-all, and that's just a short answer or contribution that I've made. So have a look at that. Bear in mind that Parliament provides delegated legislative power to the executive. Bear in mind the Commonwealth will take effect in priorities to state, and think about the way in which the government lawfully lawfully makes and exercise its power, not makes and exercise its power. The case of Vonson and Forestry Commission is a good one in this context. Okay, now I'll just stop the share. Are there any questions? Does anyone have any comments, questions, thoughts? Remember, next week, 7:30 p.m. Thanks for your attendance tonight. I'll stop the recording now, and all the best, and we'll continue to chat in U Crew during the week. All the best.